In the name of God, the most gracious, the most merciful. Peace be upon you all. In the previous video, while analyzing the same three situations, we observed that our traditional scholars face significant challenges in the division of inheritance. In response, they have proposed various solutions to overcome these difficulties. However, when we applied the solutions derived by the traditional scholars to these three cases, according to their own understanding, and compared them with the original distribution of shares as outlined in the Quran, we found it impossible to execute the division of inheritance in accordance with the traditional scholars' interpretation of the Quranic directives. Now, let us investigate whether these problems in inheritance distribution arising from a specific understanding of the verses can be resolved through an alternate interpretation. Could there be an understanding of the Quranic law of inheritance that does not lead to the challenges which force the traditional scholars to alter the very framework presented in the Holy Quran? Let us find out. Once again, analyzing the same three cases, let us explore whether any scholar has arrived at a different interpretation. If so, what principles underlie their disagreement with the traditional scholars? And does the outcome of their deliberation allow for the successful implementation of the shares as explained in the Quran according to their understanding? Please recall that we have already discussed the traditional scholars' interpretation of the Quranic distribution, its consequences, the challenges it poses, and their proposed solutions. So far, it has been clearly established that the traditional scholars have not been able to distribute inheritance shares as per the Holy Quran. Now we shall examine an interpretation that differs from that of the traditional scholars, a perspective propagated by Javed Ahmed Ghamidi in his book Meezan. Using the same three scenarios, we will now try to understand how Ghamidi Sahab interprets the Quranic guidance on inheritance. If he diverges from the traditional scholars, what are the arguments he offers? And crucially, is he able to execute the inheritance shares as per the Holy Quran, an outcome considered mathematically impossible under the traditional scholars' interpretation? Let us look at situation 1. The parents were allocated 33.33%, that is 1/3 of the total estate. The daughters were given 66.66%, 2/3. This made it impossible to allocate 25%, 1/4 to the husband. After allocating rupees 4 to the parents, rupees 2 each, and rupees 8 to the daughters, the inheritance was exhausted. The question remained, how could the husband's share be delivered? In this case, the traditional scholars interpreted the Holy Quran to mean that the daughters are to receive 2/3 of the entire inheritance. They based this on the following verse, "And if there are only daughters 2 or more, then for them is 2/3 of what he leaves." Ghamidi Sahab disagrees with this understanding. According to him, the Quranic guidance on inheritance does not end with the mention of the children's shares. The same verse continues. According to Ghamidi Sahab, this indicates that the parents' shares are to be allocated before the daughter's shares. Therefore, he reads the full instruction of the verse as, "And if there are only daughters, 2 or more, then for them is 2/3 of what he leaves, and if there is only one, for her is half. And for one's parents, to each one of them is 1/6 of what he leaves." Ghamidi Sahab argues that the language of this verse demands that the parents' share be extracted first from the total inheritance. The daughter's share is then to be taken from the remaining estate. How did he arrive at this reading? He offers a simple analogy to explain the structure of the language. Imagine we say, "This money is for the children. The boys will receive double the share of the girls. If there are only girls, they should get 2/3, but half of the amount is for your father." If the final statement about the father were omitted, then the entire amount would be distributed among the children, and the girls would indeed receive 2/3 in the absence of boys. However, the concluding sentence, "half of the amount is for your father," overrides the earlier allocation. Therefore, the father's share must be deducted first. According to Ghamidi Sahab, this conforms with universally accepted linguistic principles. When an additional clause is introduced at the end, it qualifies and modifies what precedes it. The instruction only becomes complete when all parts are considered together. Hence, in the Quranic directive, the instruction regarding the children's shares is followed by a clear statement regarding the parents' shares. The only coherent way to read this is to first allocate the parents' share from the total and then distribute the remainder among the children. Thus, in Ghamidi Sahab's view, the daughters receive 2/3 of the remaining estate, not 2/3 of the total. He extends this same logic to the husband's share. After the parents' share is allocated, the Quran says, "And for you is half of what your wives leave if they have no child. But if they have a child, then for you is 1/4 of what they leave." Ghamidi Sahab notes that this statement about the spouse comes after the parents' shares, indicating that it too is to be deducted from the remaining estate. To illustrate, he offers another analogy. Suppose we say the entire amount is to be distributed among Zaid, Usman and Ali equally. But in the absence of Zaid, Usman gets 2/3 and Ali 1/3, and rupees 10 must be given to the husband. Here, even though it initially seems that Usman and Ali receive the whole amount, the final sentence requires that rupees 10 be given to the husband first, and only then is the remainder to be distributed between Usman and Ali. Ghamidi Sahab argues that the Quran employs a similar linguistic structure. Is this interpretation alien to traditional Islamic scholarship? Not at all. In fact, the traditional scholars and jurists use the same method when distributing inheritance among sons and daughters. The parents and spouse are allocated their shares from the total, and the remainder is then distributed among the children. The renowned scholar Abu Bakr al-Jassas, in his work Ahkam al-Quran, writes, "A boy receives twice the share of a girl." This directive is beneficial in that it allows us to first allocate the shares of other heirs such as parents and spouses, and then distribute the remainder among the children. Where both sons and daughters are present, jurists first allocate the shares of the parents and spouse from the total inheritance and then divide the remainder among the progeny. There is no choice but to first give the definite shares to living parents or spouses because the verses have clearly defined them. Only afterward is the instruction applicable that a male shall receive twice the share of a female. It is not stated that a son is to receive 20%, 30%, or 40% of the total estate. Rather, his share is simply double that of a daughter. Hence, fixed shares must be deducted first, and only then is the remaining inheritance divided among the sons and daughters accordingly. This structure of expression in the Holy Quran can be likened to the following example. All these donuts are for the children. Distribute them among them, but give one each to the mother and the father first. If we had 10 donuts, it is not stated that the children should receive 8. What is explicitly stated is that the parents must receive 1 donut each. Therefore, reason and common sense dictate that we first allocate 1 donut each to the mother and father, and only then distribute the remaining donuts, whatever their number, among the children. When the Holy Quran states that God decrees regarding your progeny that the share of 1 son is equal to the share of 2 daughters, and then goes on to state that if the deceased had only daughters, 2 or more, they are to receive 2/3 of the total estate, and if there is only 1 daughter, she should receive half, and that the deceased's parents are each to receive 1/6 of the inheritance, the guidance becomes clear. It is evident then that in the case where the deceased leaves behind only daughters, the instruction that they are to receive 2/3 of the estate is an exception to the general rule that a male receives twice the share of a female. Therefore, the same principle that applied earlier continues to apply here as well. Let us now examine these Quranic instructions as interpreted by Ghamidi Sahib. يُوصِيكُمُ اللَّهُ فِي أَوْلَادِكُمْ لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ. God commands you regarding your children, for the male a share equal to that of 2 females. This is followed by فَإِن كُنَّ نِسَاءً فَوْقَ اثْنَتَيْنِ فَلَهُنَّ ثُلُثَا مَا تَرَكَ وَإِن كَانَتْ وَاحِدَةً فَلَهَا النِّصْفُ. But if there are only daughters, 2 or more, for them is 2/3 of what he leaves. And if there is only 1, for her is half. And finally, وَلِأَبَوَيْهِ لِكُلِّ وَاحِدٍ مِّنْهُمَا لِسُدُسُ مِمَّا تَرَكَ. And for the parents, to each of them is 1/6 of what he leaves. This last statement, وَلِأَبَوَيْهِ لِكُلِّ وَاحِدٍ مِّنْهُمَا لِسُدُسُ مِمَّا تَرَكَ begins with the conjunction wa, indicating that it is connected to the preceding verses. The first verse begins with يُوصِيكُمُ اللَّهُ فِي أَوْلَادِكُمْ لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ. If these verses are read together, the full statement becomes يُوصِيكُمُ اللَّهُ فِي أَوْلَادِكُمْ لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ وَلِأَبَوَيْهِ لِكُلِّ وَاحِدٍ مِّنْهُمَا لِلسُّدُسُ مِمَّا تَرَكَ, which translates to, God instructs you concerning your children. For the male, a share equal to that of 2 females, and for each of his parents 1/6 of what he leaves. Between these 2 clauses is فَإِن كُنَّ نِسَاءً فَوْقَ اثْنَتَيْنِ فَلَهُنَّ ثُلُثَا مَا تَرَكَ وَإِن كَانَتْ وَاحِدَةً فَلَهَا النِّصْفُ. That is, but if there are only daughters, 2 or more, for them is 2/3 of what he leaves, and if there is only one, for her is half. According to Ghamidi Sahab, this middle part begins with fa, which introduces an exception or conditional clause, thereby separating it from the first. The letter fa functions as a conjunctive, introducing a new, distinct scenario. Thus, the first clause outlines the distribution when there are both sons and daughters, while the clause beginning with fa introduces a separate case when there are only daughters. The final clause beginning with wa, wali abawayhi likulli wahidin minhuma lissudusu mimma taraka connects back to both prior scenarios, while the clause beginning with fa introduces a separate case, فَإِن كُنَّ نِسَاءً فَوْقَ إِثْنَتَيْنِ فَلَهُنَّ ثُلُثَا مَا تَرَكَ وَإِن كَانَتْ وَحِدَةً فَلَهَا لَلنِّصْفُ وَلِأَبَوَيْهِ لِكُلِّ وَاحِدٍ مِّنْهُمَا لِلسُّدُسُ مِمَّا تَرَكَ, which means, but if there are only daughters, 2 or more, for them is 2/3 of what he leaves. And if there is only one, for her is half. And for each parent, 1/6 of what he leaves. Hence, when the progeny consists only of daughters, whether one or more, they are to be given their share after each parent has received 1/6 from the total estate. According to Ghamidi Sahab, the concluding clause, wali abawayhi likulli wahidin minhuma lissudusu mimma taraka applies to the entirety of the preceding instructions. Therefore, a close examination of these verses makes it evident that just as the parents are allocated shares from the total assets, so too must the husband be given his share from the total before distributing the rest to the children. Let us now examine how Ghamidi Sahab interprets the distribution in the case which the traditional scholars considered mathematically impossible according to the Quranic instructions. The total estate is 12 rupees to be divided among the parents, husband and daughters. According to Ghamidi Sahab's understanding of the Quranic directives, when children are present, each parent receives 1/6 of the total, 16.66% each. Therefore, the mother and father receive rupees 2 each, totaling rupees 4. This leaves rupees 8. Now the husband's share must be allocated. In the presence of children, his share is 1/4 or 25% of the total, as stated in فَإِن كَانَ لَهُنَّ وَلَدٌ فَلَكُمُ الرُّبُعُ مِمَّا تَرَكْنَ. But if they have children, then for you, husbands, is 1/4 of what they, wives, leave. 1/4 of rupees 12 is rupees 3, which is to be allocated from the total. After paying rupees 3 to the husband, we are left with rupees 5. According to Ghamidi Sahab, the Quran instructs that if the progeny consists only of daughters, their share of 2/3 is taken from the remaining assets from rupees 5. 2/3 of rupees 5 is approximately rupees 3.33, which is then distributed among the daughters. According to Ghamidi Sahab's interpretation, every heir has now received their rightful Quranic share. The parents collectively received 1/3, rupees 4. The husband received 1/4, 1 rupee, 3. The daughters received 2/3 of the remaining rupees 5, which equals rupees 3.33. After distributing all the shares, rupees 1.76 remains. What should be done with this leftover amount? Ghamidi Sahab states that this should be distributed according to the will, wasiyah, of the deceased. The remaining assets may be either given to any one of the heirs, or given exclusively to the daughters, or they may be passed on to a relative mentioned in the will, or even given to a non-relative, as there is no restriction in the Quran regarding this. The Holy Quran provides guidance on this in the verses related to kalala, which will be discussed in another case. If none of the above options are available, Ghamidi Sahab invokes the principle, aqrabu lakum naf'an, those who are of most benefit to you. In such a case, the remaining assets are to be given to the deceased's closest male relative, following the principles of the Quran and the teachings of the Prophet, peace be upon him. In situation 1, where the traditional scholars were unable to allocate the husband's share after distributing to the parents and daughters, they ultimately modified the Quranic injunction by reducing all shares to make space for the husband's portion. Ghamidi Sahab, however, rejects this interpretation, arguing that the issue does not arise at all if the language of the Quran is understood precisely and holistically. In conclusion, according to the traditional scholars, daughters receive 2/3 of the total estate. According to Ghamidi Sahab, daughters receive 2/3 of what remains after the parents and husband receive their shares. By following Ghamidi Sahab's interpretation of the Quranic law of inheritance, no mathematical inconsistencies arise in the first case. He did not need to alter the shares specified in the Quran, nor did he deprive any heir of their rightful portion. In the next video, we shall examine whether Ghamidi Sahab can apply the same method to the remaining two cases and whether he can successfully resolve them in light of the Quranic instructions. Will he encounter the same obstacles the traditional scholars faced in their interpretation?